Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, joined here by criminal defense attorney Phillip Hamilton. And thanks for joining us here on the program where we break down the biggest live trials and legal stories in the news today. We'll get started right now with what's on the docket. All right, so she's under cross-examination by Simon's attorneys. And let's not forget what she testified to previously, that she knew that there was this complaint about a sports medicine doctor. She was setting up an investigation into it. She met with Lou-Anna Simon. The question is, did she specifically say Nassar? And what she testified to earlier, I cannot recall stating to President Simon a matter involving Larry Nassar. Now, Phillip, you tell me in this preliminary hearing stage, is this enough to show that the prosecution doesn't have a case and this shouldn't go to trial?
It's highly relevant. It's highly relevant because everything is boiling down to what did Simon know, right? What was she made aware of? So you can even hear on cross with respect to Simon's attorneys questioning whether or not it's normal with respect to a Title IX investigation to make its way all the way up to the president's office. Granberry Russell here is kind of, she's in a tough situation, but the thing is, I think that she's able to credibly kind of not remember some of these details only to the extent that it was 5 years ago when these initial allegations kind of came about. Now, clearly, Granberry Russell has some issues with these emails being sent to her personal account. Sounds a little bit familiar, but we're not going to go into politics. But there's some issues there just in terms of what was known, when was it known, and more specifically, when did Simon know it?
This is so specific because the prosecution is saying that Lou-Anna Simon deliberately lied to investigators about what she really knew, that she knew Nassar was being investigated. But the question is, did she know, or did she just know it was a sports medicine doctor? Let's take a break. When we come back, we're going to jump live. And again, we are in Verdict Watch in John Chuck. We'll be right back. Okay, so let's break some of this down right now. She is an interesting witness. I mean, let's not go back. So she was part of this Title IX investigation to look at discrimination or abuse on campus. The whole question is about a conversation she had with Lou-Anna Simon, but also how she got the information was from an investigator in her department who had this complaint from Amanda Tomashow, who's one of the women who accused Larry Nassar of sexual abuse. And when she was asked about, okay, so you learned about this communication, you learned about the investigation, you had a conversation with your investigator, what do you remember about it? She goes, I don't remember the call, I don't remember anything being discussed in that call, I don't remember the time, I don't remember the day. Now she's also saying she doesn't even know what she told Lou-Anna Simon. Is this suspicious? Is this a cover-up? Or is this really, like you said, so many years ago, who knows what to remember?
Well, it depends on what side of the podium you're on, Jesse. I mean, if you're, the prosecution in the state of Michigan moving forward on this, this is absolutely a cover-up. The reason why you don't remember anything is because whether implicitly or explicitly, you've kind of been advised not to, right? Like without it necessarily having been said, but you understand to the extent that you're starting to remember concretely and concisely, information that was given to you by Investigator Moore, and if that trickled its way up, either to Simon or to someone, within her office, that potentially puts MSU within a lot of liability, right? And to the extent that they're liable,
right,
they have every incentive to potentially kind of like, if you don't remember it specifically, just don't say you don't remember it at all.
How tough is it to prove knowledge on the part of a defendant?
It's hard to prove knowledge whether it's on any angle, whether you're a defense attorney cross-examining sometimes a complainant, or whether you're cross-examining another witness, or whether you're clearly a prosecutor trying to prove intent on behalf of a defendant. It is very difficult to prove what's going on in someone's mind. As you're aware, there has to be a lot of corroborating circumstantial evidence that can kind of prove up ultimately beyond, here it's not beyond a reasonable doubt, it's more likely than not the lower standard within the preliminary hearing. But no matter what the standard is, it's always going to be difficult to prove what's going on in someone's mind. I've had jurors specifically after trials wherein the matter involved my client's intent just come and say, look, at the end of the day, we can't really say what your client was thinking. And that's ultimately why we had to come back with the acquittal. I mean, I've had that in verbatim said to me, so it's always going to be difficult, Jesse.
It's all up to the judge here to determine if there's enough evidence to go forward. And from what we're looking at so far, there's a question of that. There's a question of whether or not this even will go forward. And we're going to have an opportunity to talk about why the state brought these charges as well. That's an interesting question to focus on. I do want to let you know, we're also, as you can see, in Verdict Watch in the John Chuck case out of Florida. As soon as we have an update, we'll make sure to let you know. We're going to take a quick break. We'll be right back. You know what's interesting about this, Phillip, is we're still trying to debate whether or not there's enough evidence to even go to a trial. This gives you a glimpse, you tell me if I'm wrong, of what a trial might look like. Would a jury convict her on all this?
Let me tell you, as the defense attorney, I'm so happy right now if I'm standing behind that podium, because this is clearly going to be one of the prosecution's key witnesses, right? Because she's one of the higher ups who had information that could have made its way over to Simon. She doesn't remember a thing, right? Like, she doesn't recall anything. And what the defense attorney is doing right now is basically just kind of locking her into a box, almost using this as like a quasi deposition to just make sure that they are good for trial, that there's not going to be any surprise answers, that, you know, the prosecution can't potentially threaten, you know, this witness with some jail time if she doesn't come forward with a little bit more information. You know, to the extent that she comes forward with anything else at trial now as the defense attorney, it's just like, look, we had a very lengthy preliminary hearing where you were asked every question in the world, and 98% of those questions, you didn't remember anything. Now at trial, you remember all of this information. I mean, I am so happy right now as that defense attorney. If I'm Simon, I'm happy. I think that's why we see her sitting there relaxed.
You talk about questions. My question is, what is the judge thinking right now? That's the #1 question. What is the judge thinking as this testimony continues in the preliminary hearing, day 4? That's the question. We're going to take a quick break. When we come back, we're going to jump live in this courtroom. And again, we are on Verdict Watch in the John Johnchuk trial. We'll be right back. Okay, so what the most interesting part about this so far has been where she said she wouldn't have had Simon be a part of the investigation. That was a huge moment for the defense. Is there anything that they're missing? I mean, because they seem to be hitting a lot of points.
They're hitting a lot of points. You know, if I'm defense attorney, I'm still very happy. The one thing I would probably want to hit on, however, in the preliminary hearing, there was the issue with respect to Granberry Russell on that May 19th, 2014 meeting. On her folder that was kind of like bearing down the agenda for the meeting, there was a note that said something along the lines of, you know, Larry Nasser S.A. S.A. was shorthand for sexual assault. That was kind of on the agenda with respect to the meeting she had with Simon. As a defense attorney, you want to explore that now, as opposed to waiting until trial. You want to figure out what the answers are, even to the extent that this moves forward to trial. The answer can't necessarily hurt you because at least now you'll have it in the event that it goes to trial. If it goes to trial to then try to explore it then and you don't have her answer on record as to why was this on her folder, and then, you know, they're trying to make the connection that she had the conversation with Simon about that, could be potentially problematic. Explore it.
It's so specific and so knowledge-based, and really an interesting discussion about what was going on at Michigan State University. It's a whole question here. The reason they brought the charges, was this a cover-up or not? That's the question. We're going to take a break. When we come back, we're going to jump live in this courtroom. And again, as you can see, we are carefully monitoring John Johnchuk. We'll be right back.